meant for me. So, as you are aware that in 2019-20, the union government initiated a process. You know what was that process? The process of law reform by requesting various law universities and judicial academies, police academies, home departments of various states, and judicial officers, police officers, prosecutorial department to give their inputs to the criminal law reform process. So officially, the launch was 2019. Then the government consulted various universities. They invited the different proposals from the law universities, law teaching institutions, and at the National Law University, Delhi, I also received such communication. In response to that, we have prepared a comprehensive, proposal to suggest the reforms in the criminal laws. And we made a presentation in the Ministry of Home Affairs in the presence of Union Home Minister. And finally, on 4th of May, 2020, the Committee on Criminal Law Reform was constituted under the chairmanship of the Vice Chancellor of National Law University, Delhi. And initially, there were 5 members, but we expanded the committee in terms of adding the researchers, the consultants, a large number of lawyers, retired judges. So around 70 to 80 people worked with this committee, and I acted as a convener of this committee. The aim of this committee was to recommend reforms in the criminal laws of the country in a principled, effective, and efficient manner. These 3 keywords are very important, which you see today in the reformed criminal laws. The whole focus is to have a principled, effective, and efficient criminal law. So these were the very important aspects which are very important. And therefore, we also yes, the committee submitted its report to the Ministry of Home Affairs in 2022. But I must tell you, sorry for interruption. So this submission of this report process, though happened in 2022, but as I have said, as many as 70 people worked on this, and we had around the 2 committee at the government level also took 158 deliberation with various stakeholders. And the aim of this entire exercise was to enable these 3 laws. So if you see the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suksha Sanhita, and Bharatiya Sakshya Adhiniyam bills were introduced in the parliament on August 11, 2023. And they were referred to a parliamentary committee, the standing committee in the Ministry of Home Affairs. The bills were again reintroduced in the parliament on 21st December 2023 and received the presidential assent on 25th of December 2023. The act came into force from July 1st. I Before I go into all other aspects of several details regarding these laws, we should actually happened in this entire process. The India's criminal laws were rooted in the extensive codification conducted in the early 1830 by the first law commission under the chairmanship of uh, Macaulay. Although piecemeal changes were made to the laws over a century and a half, the fundamental remained the same. So, despite 76 years since independence, the laws reflected the socio-political beliefs and legal discourses of the colonial era. And therefore, this committee has looked into all those things. To the viewers, I'll share certain very important insights which are nowhere, because as I have said, I'll tell you certain things which are not available in public domain. The law students and the faculty of law must understand that what were the principles governing these reforms. This is very important, because these, when I say these are the principled reforms, so what are the principles which have been followed would be interesting for you to know. There were 11 principles which we have followed in the whole discussion on this matter. The first principle was the primacy of the Constitution. Because when Macaulay drafted these criminal laws, the Constitution was not there. And therefore, these laws couldn't capture the essence of constitutionalism or constitutional aspects governing the enforcement of law. Second was primacy of human rights. Human rights again came in late 50s after the creation of UN. There was a formal accent to the human rights regimes across the nations. Therefore, the laws are also required to imbibe the spirit of human rights effectively. And therefore, we have kept this to be one of the principles. Now, the third was revisiting the relationship between the state and the individual. Criminal law constitutes a relationship of the state with the people, and this nature should not be that of coercion, retribution, or vengeance. Rather, it is important to redefine this relationship, which we have effectively done in this reform process. Fourth was victim justice. So, centralizing the victim in the course of criminal adjudication continues to be a very important aspect which we have effectively dealt. And if you see the Bharatiya Nagrik Suraksha Sanhita, it has captured the idea of victim justice very effectively. And next was the balancing the rights of the victims vis-a-vis accused. So victims' right and accused rights both are important, and any law reform process should include or incorporate this particular aspect. Fair and time-bound trial was another principle which we have inserted in the reform process. Next was simplified, unambiguous, and consistent procedure. If we have to achieve the efficiency, the procedure has to be simplified, unambiguous, and consistent. Next was transparency and accountability, for which we have made a large number of provisions where the agencies of criminal justice were put to a kind of accountability, and they were also required now to provide certain information to the stakeholders in a limited time period. The next was the infusing the technocentricity. Technology is becoming very, very central, and now this is the time to have it as a principle in the law reform process. This has also guided us. And last was principled sentencing. Sentencing process should be the uh, principled one. Now, if I come to the Bharatiya Nyaya Sanhita, at a glance, you will find there are 358 sections in Bharatiya Nyaya Sanhita. There are 20 new offenses which we have introduced in these laws. Or revise the punishment scheme. In 23 offenses, a mandatory minimum sentence has been enforced. Fine has been enhanced in as many as 23 offenses. And in some cases, the punishment was also reduced. Reorganization of the provision by having a rechapterization is another thing. Now, I'll come to bail law reform, prosecution reform, sentencing reform, victim justice reform, and impetus to forensic was something which has been done. Now, let us understand the key reforms which Bharatiya Nyaya Sanhita has. But before that, I'll ask you, though you won't be able to talk to me at this stage, but ideally, you should be talking. Then only a speaker gets the impetus and motivation. Let us understand that there is a discourse going around these criminal laws. Some are saying that these criminal laws are creating a police raj. These criminal law will snatch the freedom of the people. These criminal laws will do that. I'll tell you something which you as a law professors must understand. That criminal law is a one fringe of criminal justice administration. You cannot alter everything by reforming the law. No such excessive power has been given to the police. Rather, police has been made more accountable than ever before as far as these laws are concerned. I also say that people, and I was speaking to some gathering earlier this month, there were members of civil society. They said, these laws are very harsh. Criminal law is punishing people. Criminal law, you have increased punishment. And it will take people into custody and all those things. I said, as a law professor, you will understand that what is the nature of criminal law. You know, power and pain is central to the enforcement of criminal law. Exercises an authority of the state to control the people. Controlling the people for the purpose of safety and security of the society is the key function of the criminal law. Criminal law is not a private law. In private law, the individual rights take precedence over community's right. In criminal law, society's right takes precedence. So in the larger social interest, the individual rights can be curtailed. That is the principle. I'm not saying curtailed means they should be illegally detained. It has to be done by a procedure established by the law. Procedure established by the law is central to the requirement of the operation of criminal law. Operation of criminal law necessarily involves a delivery of pain. Delivery of pain is the key function of criminal law. Unfortunately, criminal law does not generate happiness against whom it is inflicted upon. Can you think criminal law brings pleasure? Criminal law brings pain. Criminal law cannot be pleasant because it has been designed to create those inconveniences in the life of people who have done some wrongdoing. It is not for innocent person. So a person who has been found guilty has to undergo some kind of inconveniences as a measure of punishment. So criminal law has been entrusted with the responsibility of inflicting certain degree of pain for the wrongdoing that he has done. For that, you need to arrest the person. Now, NGOs, people say you are arresting the people. I am saying arresting is a lawful exercise. You have to take the person in custody. You have to maybe extend the custody. You have to interrogate a person. These are the lawful process. I am not saying and justifying that the torture should be done or uh, any kind of coercion should be done. However, the basic operation of criminal law would come with certain degree of coercion. So if a person is arrested, will he be happy? Actually, operation of criminal law makes a lot of people unhappy. All people, family members will be unhappy. So the neighbors would be unhappy, relatives would be unhappy. Only your enemies will be happy. Rest would be unhappy. So that is the basic operation of criminal. Criminal law is something which causes these hardship because it has been designed to cause these. And criminal law is a kind of communication of the state to condemn the action of the individual contrary to the norms of the society. So, substantive understanding of criminal law is about its ability to create a social stability and a sense of order and peace in the society so that enjoyment of rights by the people remain unhindered. Those who want to live in peace, they should have a guarantee. So, today you are sitting peacefully in your rooms without keeping your camera on despite my request because law allows you law allows you to move anywhere. Law allows you complete freedom. You can listen to me, you cannot listen to me. No coercion is possible here. So power and pain, as I have said, is quite said. Criminal law does not have many positive ways to turn the people to be law abiding. Criminal law के पास कोई जरिया नहीं. Criminal law has to communicate the consequences of the acts of people of through punishment and deprivations. So we will snatch your fundamental freedoms and liberty if you indulge in wrongdoing. So criminal law keeps evolving. So today's criminal law is X, tomorrow's criminal law would be Y. We may be more liberal in granting forgiveness to the people, in granting plea bargaining, in granting probation. So society is becoming liberal. We are contemplating a very liberal criminal law in a constitutional democracy because these are our people. The only problem is with criminal law contemplates a wrongdoing not as a private act. It's a disturbance to the people's peace. Society's peace is violated. Therefore, a major operation is needed. And if you see, Alan Norrie, you know, he said in his book, Crime, Reason, and History, that far from being freestanding foundation for a rational criminal law, the central principles of the law are a site of struggle and contradictions. So criminal law has to operate in a contradictions because on the one hand, Constitution wants the citizen to be free in all respects and enjoy their right to life. However, criminal law interferes with these freedom and brings those restrictions which are detrimental to these fundamental freedoms. That is the contradiction of criminal. Therefore, you need to be very careful about the scholarship and the intellectual discourses. But the point which I am raising and what happened these days to these laws, these laws are there. They have brought a lot of changes, but the fate of these law will depend on one major thing, and which I am telling you, the capacity of the criminal justice system to enforce these laws. I ask you a question, whether the current criminal law regime has that capacity, infrastructural, resource, and intellectual to enforce these laws, these aspirational laws, which are ambitious enough to prescribe a number of innovative methods. So, like we have prescribed in Bharatiya Nagrik Suraksha Sanhita, strict timelines for the disposal of cases at different levels. Now, the extent to which we would be in a position to satisfy these timelines would depend on the what kind of resources you are providing to the system. So, capacity of the criminal justice system. At the moment, there are less than 20 judges on per 100,000 people in this country. This ratio may be several times higher and better in many countries. You have limited number, you have police officer, hardly 200 police officer on 100. You have only, say, 15,000 prosecutors, whereas we need some 50,000 prosecutors. So the capacity of the system is very, very important. Another point which you need to understand, a system's efficiency is contingent upon the perceived legitimacy of the criminal justice system by the people at large. So generally, people in this country are not generally happy with police and also other organs of the system. They think that police is against the people. So legitimacy crisis is being faced by the criminal justice system quite remarkably. Similarly, the poor and disadvantaged sections of the society are also not treated well by the system. There is a general experience. Because if you say the population of our prisons, 65% people come from a very lower socioeconomic strata. So all these things will bring the question of equitable enforcement of law, because systems biased towards the privileged and powerful often results in leniency or impunity for those who wield the influence, while the underprivileged and marginalized communities face a disproportionate burden of punitive measures. This is a very crucial thing to understand. And when I say so, I also need to tell you that a lot of things in the criminal justice system that we do, they are not, I mean, dependent on the principles. So like there is a over criminalization. We want to make a lot of human acts to be criminal. We are criminalizing a lot. Even civil actions are being criminalized. Then there is a need to understand what defines the criminalization. Another thing that I'll take you to the Bharatiya Nagrik Suraksha Sanhita. There are a couple of things which we have done. First of all, any act, so sovereignty of the community, the country under 152 now sedition has been scrapped. But the point, a lot of people and critics are talking that you have given very wide range of powers to the state, because anybody can be prosecuted for endangering act against the sovereignty and unity and integrity of the country. This is not a fact, actually, because any act which has a detrimental consequence and committed with certain degree of malice would attract this particular section. Mob lynching has been introduced in section 103, subclass 2, because a lot of people in the past have taken the laws in their hands to lynch the people, and there was a need to address this criminality, because criminality and peace cannot exist in the society. Those who are talking about human rights, they must understand that these crimes are a major threat against the enjoyment of human rights by the peace-loving people. So the introduction of organized crime and terrorism in general criminal law of the country is also a step forward to provide a sense of security to the people against these activities. Chain snatching, sexual intercourse by employing deceitful means under section 69 is something. But there is a modification in old offenses also. So, number of offenses, criminal breach of trust, punishment for rash and negligent driving, uh, rash and negligent act by medical practitioner, punishment introduced for hit and run, where a driver escapes without reporting the same to the police under section 106. 2, however, it has been withheld for some reason. There are deletion. So sedition, 377, attempt to commit suicide, etc. have been deleted. Punishment is something which is very, very central, because many people have objection why you are punishing the people. But I have given you an idea why criminal law punishes. Let us understand that mandatory minimum punishment in 23 offenses such as organized crime, terrorist crime, dacoit. I also have reservation against mandatory minimum punishment in general, but probably the intention of the legislature here was to make sure that the offenses like organized crime, terrorist crime, dacoity, etc., should not escape with lighter punishment for want of various procedural requirement, evidentiary requirement at the trial level. But enhancement of punishment in culpable, homel, hurt, wrongful confinement, rioting is also there. So these are the cases. But the good introduction is the introduction of community service, introduction of community sentence as a form of punishment is also there. So this is interesting. Bharatiya Nagrik Shiksha Sanhita, actually it brings in the audiovisual electronic means in its fold in a very comprehensive way, and technological updation as evidence of a witness may be taken through audiovisual electronics. Physical appearance of the accused at the time of framing of charges has been dispensed with, where the accused is present or through audiovisual means. So this is a great, support and help to the people, preventing them to come to the court again and again for various reasons. Now, judgment to be uploaded on the court's online portal within 7 days of its declaration. This is another technological imposition. Witness can, I have already said, can give the testimony online and through audiovisual. Procedural reforms are also there, number of reforms. But most significant reform is the victim assistance and witness protection under Nagrik Suraksha Sanhita. Section 173, subclass 2, requires the copy of FIR to be provided to the victim. This right was missing in the previous law. Now, victim becomes entitled to have this copy. Police officer is made under duty wow, to inform the victim about the progress of the case, which was not there in earlier case. Supply of document has also been made a right. Mandatory first aid, medical treatment, and all these things are now there. Speedy justice, as I have said, the introduction of timelines, because this is a bold step which could not be done earlier, because the victim informants are informed about the investigation within 90 days, trial in absentia against proclaimed offender within 90 days. You know, summary trials have been introduced, but FIR to be taken on record within 3 days from the informant's signature. Preliminary inquiry, which is now the part, will be conducted within 14 days. Supply of police report, 40 days. Further investigation, if at all needed, 90 days. Framing of charge, 60 days. So these are the interesting time. Trial in absentia is another addition. So if a proclaimed offender who is evading the trial and willfully not appearing before the court, with the help of the prosecution and defense lawyer, can proceed against such person in trial in absentia. So this is very, very important. Forensic aspect has been added in all such cases. Similarly, Bharatiya Sakshya Adhiniyam, we have admissibility and of electronic and digital records, given some legal validity to it, and they have been now considered to be primary evidence. uh, we have defined what is audiovisual or electronic evidences in the law. Electronic record admissibility has also been accepted under these laws. So focus of the new criminal laws has been shifted from punishment to justice, because you require justice to be delivered, to be able to bring the enjoyment, because ultimately the criminal law has to serve the society. So I only say that criminal law is an essential feature of the society. And of course, my view is this textual law transformation are not alone would bring the result. You have to build up the capacity of the system much. But in a constitutional democracy, we need to have what I call minimalist criminal law rather than a very harsh criminal law. And I'm sure criminal law will become a public utility by which the society will perform a large number of functions for the peaceful living of the people in this country. So with these words, I close. If you have any question, I can answer. So thank you so much for your attention.
Thank you, sir. We do have questions in the chat box. If you allow me, I can put them across to you. Sir, you are muted.
Yeah.
Yeah. So there's a question by Ms. Ananya that she says that if the incident of a crime that took place on 30th of June 2024 and the FIR was registered on 1st of July 2024, whether the old criminal laws would be applicable or the new ones or the combination of both.
See, these technicalities are going to be there. But in such case, since crime has taken place on 30th June, FIR is taking place on July 1. The option of old criminal law is more significantly open, because that was the day on which the commission of crime took place. Reporting is a different thing. Reporting can be delayed by not one day. Reporting sometime happens after a fortnight. So naturally that would apply.
All right.
Yeah,
Sir, I myself have a question that
yeah.
with these new criminal laws, sir, we are definitely bringing in reforms in the procedural law and the substantive criminal law. But the criminal justice system comprises of courts as a very significant stakeholder. So, with these new criminal laws, do you foresee any reforms or any changes that even our judiciary should look forward to in order to have a effective implementation of these laws?
I have said in my lecture that we have brought reforms in laws, criminal laws. We have not brought reforms in criminal justice system.
Mm.
Criminal justice system is different from criminal laws. So institutions of criminal law are different from the criminal law itself. So judiciary is an institution of law. Judicial reform is a whole exercise which is undergoing, and it require. I said unless you have the capacity to enforce these laws will not. Capacity would involve the resources. So courts are already understaffed, at least lower court, if I say, in terms of judges, in terms of prosecutor, in terms of the court buildings. So you need to provide. So it is a state subject. Every state will have to work out a plan for implementing these laws and also to bring in the kind of resources which are required for the effective implementation of these laws.
Right. Thank you, sir. Sir, another question before I hand it over to someone else if they have any. Sir, in one of the lectures, in fact, in one of your editorials, you had shared that National Implementation Commission is important for effectively implementing these criminal laws. Could you share some insights on that?
Yeah, so I have said this for one reason, because at the moment, the law enforcement agencies, lawyers, even judges, they are struggling to find answers with respect to these changed versions of the law. Now, there should be a national implementation committee at the central level to receive all such queries here, and then a body of expert can decide the standard answers for all these queries to be disseminated to all states, because the queries will be same, like one query you have asked here, that 30th June. So similar queries are there. So I say, instead of giving one to one answer here and there, you can come out with a kind of a standard answers for most specific, general, most commonly asked questions with respect to criminal law. So a committee is definitely needed. And I'm happy to say that the MHA has responded to this suggestion, and they have constituted in the BPRND a similar committee where they will receive all such queries from all the stakeholders, for which a standard replies would be set and disseminated, so that there is no confusion with respect to the various issues relating to the implementation of these laws.
Okay. Thank you so much, sir. Any other questions from the participants? I hand over the floor to now Dr. Monica Sharma, who's the faculty convener of this of this 1 week faculty development program. Ma'am. Dr. Monica.
A very good afternoon to everyone present. Am I audible, Kriti ma'am?
Yes, yes, ma'am. Yes,
hello, Kriti ma'am. Am I audible?
Yes, ma'am.
So a very good afternoon to everyone present here. A very good afternoon to everyone present here. Now it's the opportune time for Thanksgiving. I, Dr. Monica Sharma, FDP convener, on behalf of MAIMS family, feel delighted to express gratitude. First of all, I would like to express my gratitude to the Honorable Torchbearer of our institute, Dr. Nand Kishore Garg ji, the founder, chairman, and chancellor, Maharaja Agrasen University, Baddi, Himachal Pradesh. Shri Vineet Kumar Loya ji, chairman MAIMS, and Professor Dr. Rajni Malhotra Dhingra ma'am, director MAIMS, for having given us an unwavering support and who have been a constant source of motivation. I'm running short of words to express my humble thanks to Professor Dr. G.S. Bajpai, Vice Chancellor, National Law University, for your comprehensive and enlightening discussion on the new criminal laws in India. Your insights on the necessity of reforms in criminal justice administration and the realistic expectations for the implementation timeline were particularly enlightening, highlighting the judiciary's capacity challenges and the crucial role of states in upgrading infrastructure provided valuable context. Your proposal for a national implementation committee and a dashboard for addressing challenges will be instrumental for all these stakeholders. We are grateful for your profound expertise and dedication to legal reform. Thank you for sharing your wisdom today with us, sir. Special thanks to all the HODs, faculty members, and researchers joining us. Hope you have enjoyed today's session as much as you have enjoyed previous week's session. Now I request all of you to please switch on your cameras for a group photograph. Thank you. Have a great day. Keep learning. Thanks once again.
Thank you. Thank you, everyone.
Thank you, sir.
Yes, sir.
Thank you, sir.